Our world is increasingly global and integrated in nature, and new technologies become part of the fabric of life at an increasingly rapid rate. Well, this will come as news to no one. Rapid change is the order of the day. But have you ever stopped to consider the implications for the rule of law and practice of law? To remain vital, the legal profession must be able to address today's concern and anticipate tomorrow's issues. This week on Dialogue, Enduring Traditions, Emerging Challenges, Law in the 21st Century. Hello again and welcome to the Woodrow Wilson International Center for Scholars in Washington, D.C. I'm John Molesky. Each week, Dialogue explores the world of ideas and issues in international affairs, history, and culture. Our guests today are Carolyn Lamm and Beth Simone Noveck. Carolyn Lamm is an international arbitration, litigation, and trade lawyer. She is also president of the American Bar Association and is past president of the District of Columbia Bar Association. Beth Simone Noveck is the United States Deputy Chief Technology Officer and Director of the White House Open Government Initiative. She's on leave as a professor of law and director of the Institute for Information Law and Policy at New York Law School. Welcome to the program. Thanks for being here.
Good to be here.
Maybe, Carolyn, we jump in with a description of Law Day, since we're doing this program along with the ABA's Division for Public Education in recognition of Law Day. You could tell us about the tradition of Law Day.
Absolutely. In 1958, President Eisenhower first proclaimed Law Day as a day when we recognize the importance of the rule of law, governance by the rule of law, and the importance of law to our society. And it has endured all the way through to President Obama issuing a similar Law Day decree. And as part of the celebration, we have a lot of educational things going on in the schools that we joint venture, as well as celebrating it in the bar.
And every year a theme is selected, and this year you decided to take a look at the future of law.
Absolutely, and it's because part of what I'm doing as president of the ABA this year is, in fact, looking at the future, the impact of globalization and the huge technological advances on the practice of law, and how we as lawyers must govern ourselves and change our ethical rules to accommodate, in fact, what's gone on.
And Beth, tell us about open government.
Absolutely. So my role as director of the White House Open Government Initiative is to do just that, implement the president's agenda and vision for creating a government, legal institutions, if you will, that are more open, more transparent, more participatory, and more collaborative. And we do this very much as a result of and because of the developments in new technology that we've seen over the recent years, and that will now help us to create a government that's truly more integrated and more connected to the American people in ways that we've never been able to do before, prior to the internet and prior to the development of the network technologies that Carolyn was referring to.
So this sounds like the idea of transparency on steroids. You take all these new technologies, the expectations they create, and it creates some imperatives for government.
Absolutely. Well, I think, you know, look, we live in a world where people are used to Facebook and Twitter and all the forms of technology that connect us in our social life, in our professional lives, whether we work as lawyers or any other profession. And now I think people have come to expect, as they should, that government and the political and legal institutions that run our country and our states and our cities should take advantage of these new technologies to connect people to one another and to connect them to power and to decision making. Just today, the Pew Center released a new report on technology and government, in fact, and came out with some pretty remarkable statistics on the percentage of people who are now downloading information from government websites, connecting with government websites in order to offer an opinion or participate in some way, or really taking advantage of new tools to get served by government better, to participate in government more effectively, and really to build a better relationship, we hope, that's going to ultimately make our government work better and deepen our democratic institutions.
I'm wondering, are there parallels in the world of law and the practice of law in that now, instead of calling your lawyer, maybe you Google a question and you rely on technology?
Well, that happens, and there are all kinds of people from other than the place where they are, in fact, licensed to practice law that are giving legal advice. You know, some of it for free, some of it for a small charge. I mean, I've had, in fact, instances where lawyers in Bangalore, India might be providing draft joint venture agreements in the United States. And how, in that context, do you assure the recipient that that is, in fact, competent for their use, that that lawyer knows anything about U.S. law, and how can you assure confidentiality and all of the other hallmarks of the lawyer-client relationship.
Well, let's keep running with this. Maybe we put together sort of our list of things that come to your minds, almost word association. When you think about changes and the challenges that might emerge from them, let's continue with the list. And Carolyn, you can add a few more. Beth, then we'll come to you. When you think of this theme, what first comes to mind?
Well, there are so many things, of course. I mean, of course, a major issue for lawyers is always confidentiality. And so many of the new modalities, cloud computing, there are questions about if there's a breach, who's responsible? How can the lawyer be sure if they're keeping information, their client's information off-site, that there won't be a breach, that things won't be disclosed? The same on emails. If you're communicating very substantive things back and forth, as everyone does, on email, how are you assured of confidentiality vis-a-vis the client and not disclosures?
Or can you be assured?
Or can you be? And what steps should you be taking? Can you in some way have things encoded, which many times we do? We use deal rooms where we post all the documents and multiple parties have access to those documents. Again, there are confidentiality concerns. There are many concerns that are related to doing that, but it's all the way we now practice law and do things in a very different way. And you may also have personnel that are, you know, the sun never sets on a law firm if you've got people in the Far East and in the United States, because you're working back and forth 24/7.
It's not just the cable news industry that's become 24/7. It's the entire world.
And your clients.
And your clients. So what do you think of if you were trying to identify hot spots for interested people who come to this? Where is the most activity as far as things that are percolating up that are really challenging our notion of law?
And so Carolyn's mentioned a number of the challenges or problems or potential hot button issues like confidentiality. Let me talk a little bit about some of the positive opportunities that we also see. And for me, the key words are networks and collaboration. So in the same way, when you talk about the 24/7 group and community of lawyers really that operates globally to serve a client's needs, we see the same thing in every profession now, where instead of turning to one person potentially to solve my problem, I can turn to a network of people who can solve my problem. This has interesting implications both for the legal profession, where people are used to going to their lawyer or their doctor or their firm, if you will, a single profession. Similarly in government, where there is often one person or a small government office, a group of people who are tasked with solving a problem. Think about a new world in which, where I have a problem or a question, instead of asking one person for the solution, I can tap a network of 1 million experts and find the 3 or the 10 or the 100 people in that network who have the most current and up-to-date expertise. This is the way a lot of banks work now when they want investment advice or to decide whether a deal is a good deal to do. They turn to a Rolodex of people who are connected electronically. What if we thought about doing some of the same things in government, where when I need to solve a problem about what should our open government strategy be, or how should we think about cloud computing in government, for example, that's both secure and robust and reliable and dependent, I want to really turn to the 100 people who know most about cloud computing. It's not you and not me, for sure. Maybe you, but definitely not me. But I really want to turn to the 100 people who are going to be the most up-to-date and have the most recent knowledge and get also a variety of views on any given topic. So I think that opportunity to collaborate with people in new ways really changes what we think about in terms of both citizen engagement in a government context. And for me as a lawyer and a law professor, someone who teaches students, I think about what lawyers are supposed to do first and foremost is to be problem solvers. It's something the ABA has said in its own reports, is that what lawyers do, number one, is they solve problems. And so this is a whole new way of solving problems, the social organization of the way that we solve problems than we've ever seen before.
But there is a big issue with that, and that is if you have a network and you have what would be called in our parlance a virtual law firm, so that you have people connected all over to solve problems, how are you assured of the lack of conflicts, whether or not they're involved on the other side? Can you rely on, if they come together to solve one problem, that they aren't in fact adverse? And how do you rely on the information that's being given for you to make a judgment? And we have very firm rules if you are in a law firm, but when you're kind of together in a network or in a community, how are you assured in terms of the way those people are free of conflict, and the ethical rules in all the countries in the world are not the same. So adversity is viewed differently, confidentiality is viewed differently, conflicts are viewed differently. So they all may be adhering to a different framework that they're offering a client advice from. And the client, at a minimum, needs to know that.
This boundaryless environment that you're both describing, whether it's a positive or a negative, when I think of the law, I think that jurisdiction matters, right? Which laws apply. Could you talk to us about this? How should we think about this in terms of jurisdictions? How does one supersede the other?
You know, it's interesting because jurisdiction matters, and obviously it's a very important dimension. But when you have deals done among 4 countries, or participants from 4 countries, and you're choosing a dispute resolution system that may be an arbitral system that doesn't have, it could be national, no roots in any one place, you select the law that's applicable. And while there are certain characteristics to the way you have to select that law, you're not assured that U.S. law will apply, or that U.K. law will apply, or whatever, Angolan law will apply. So it is very much, a result of the nature of the impact of globalization on the way we do business, that you're not assured that jurisdiction is the same physical presence jurisdiction, or even center of gravity jurisdiction that we always used.
Beth, there's been a faction in U.S. politics that has been very resistant to any notion of international law superseding U.S. law. How relevant is that position moving forward? It would seem globalization suggests that it will become more and more difficult for the nations of the world to not submit to some sort of coordinated international.
Absolutely, and I think to pick up on this point, you also see a lot of forum shopping, if you will, where people are able to choose their own. I mean, it's a fundament of private law in the U.S. context that people choose their own jurisdictions, sometimes for the arbitration or litigation of their disputes. But we see the same kind of thing if we sort of abstract this more to the context that I work in. Where we talk about how do people actually coordinate and collaborate, for example, to participate in a government decision-making or to give feedback. We have to set the boundaries and the rules for what that interaction will look like. And so whether that's if we're talking about the traditional choice of law, or whether we're talking about simply what the choice of rules are for any kind of engagement, it's very much the reason why you have people who are trained in the law working in the Chief Technology Officer's office, and not only people who have training in technology. It's important to have both. But the reason is because you need to understand something about the notion of creating rules and procedures by which we govern the way we interact so that we can minimize disputes, so that we can come up with what the fair rules are for interaction. People ask me all the time, if you're going to have online citizen engagement, it's a wonderful way to connect more people to their government, but what's to stop people from just screaming and shouting? What's to stop people from trying to game the system and only, essentially lobbying in new ways?
Anyone who's visited a blog knows these are real threats.
Exactly. And so what you're really trying to do is to inform government decision making and have a robust debate that's civil and civilized. Are these 4 really the best way to do it? Well, the answer is that you have to actually design the system and the process for interaction. And that's where lawyers come in really handy, is because they understand something about how to set up the rules and procedures by which, including, and then translating those procedures into technology, into the fora that we can use, whether it's to create a virtual law firm or an online citizen engagement in government, that we can then use to create robust and meaningful forms of dialogue.
It seems once that you create this expectation, if you set up this place for citizens to come and participate, now you've got to deliver, or it looks just like a gimmick. In other words, does this become essentially a threat or a potential replacement to representative democracy if you can have this more direct democracy underway?
Ask me a bigger question, John. So I think threat is the wrong word. What we have to recognize the need in this day and age, in a digital day and age, in the same way that we are looking as a society for how to revamp our music industry and journalism and the arts, and every profession is really facing this question of what does it mean to bring innovation to the way that we work. We have to do the same thing for our democracy, lest it become quickly out of date. We do have representative institutions which are designed around a time and an era in which people couldn't communicate so readily and quickly with one another. It's why we have to send professional representatives to Washington. But the world looks a little different now, where people can Google information and they can communicate with their representative and they can send me an email. And we have new forms of communication that allow us, again, to collaborate and take action in new ways that we could never imagine before. So we do have to, I think, update and upgrade. I don't think it's a threat. I think it's threatening if we don't do anything. I think what we're looking at similarly in the way all these other industries are coming up with new business models for the way that they work, we need a new business model for our legal and political institutions to take account of the reality that we're facing today.
Well, in that regard, I do want to return to the premise for your question, and that is the international law question. International law, make no mistake about it, is part of our federal legal system. There's no question. The questions involve how binding are certain principles of international law. If there's a treaty that's an opt-in, opt-out, if it's a private international law premise, whatever it is, there are questions around the edges. But international law, to be sure, is to be respected, and it's part of our legal system.
When you think about privacy moving forward, whether we're talking about security issues where you could have very invasive technology that might be able to detect if someone's trying to smuggle something onto an airplane, or in the case we were talking earlier about employees or clients and being able to monitor electronic and communication, email. Talk to me about some of the concerns you have as it relates to privacy, and also particularly, is the law keeping pace with technology in this regard?
Well, there are many different aspects to privacy, and certainly in the United States, privacy is fairly well protected under the Privacy Act, and there are also now a myriad of subsidiary acts in terms of identification information, protecting the disclosure of all of that. But actually, I think the EU standard is much higher in terms of what they have to protect and what they can disclose and not disclose.
Higher for protecting individuals' privacy.
Higher for protecting individuals' actual information. And so in that respect, I'm not sure the U.S. in terms of their privacy protection has kept up exactly. And we should be looking around to what others are doing.
As we start to think about how to create an open government and a government that's more transparent, we do that, of course, fully cognizant of the fact that we want to safeguard privacy, individual privacy, as well as create transparency on government data and information. So just to give you an example around this, and I agree that in terms of the governmental context, we have very strong protections in the public sector, probably less so in the private sector than in Europe in terms of the exchange of personal information. But we made a decision, a really historic decision, to release all the records of who comes and goes to and from the White House this past year. But the people who come and go submit their name and social security number when they do so. So that's why we don't release that information the day people come. We actually are sure that we scrub those personally identifiable data, like names, like social security number, to make sure that we're not compromising people's privacy. When the Department of Education announces that it's going to, as they did in their open government plan 2 weeks ago, unleash a major initiative to release ever more data about educational achievement and performance in America's communities, and to really try to push towards releasing data in order that people can make better choices about education within their own communities, that has to be done cognizant of the fact, and there's so many other examples like this across the government, that when we release that information that helps people make better buying choices, better decisions, solve problems better, that we do so in ways that are, again, respectful of privacy, and that we're being careful not to release data that should not be released. So that's very much part of the challenge, and again, why you have to have a complement of law and technology working together so that we respect the legal values and use technology to help us to do that. Is
the legal system agile enough to respond to these challenges, the rapidity of change and all of the issues that it's going to? I mean, you look at the political environment in Washington, and change is not happening easy these days. And so whether it's the law or whether it's healthcare reform or whatever it might be, it's not easy to make changes.
Well, and I agree. Certainly, there is always a lot of debates, or there are, and indeed in Congress to get anything through right now, I think it's very difficult, shall we say. And there are certainly opposing views, and things aren't moving very quickly. And so,
are there things in the queue in regard to our subject matter? Are there things that really require a re-examination of either law or process, or even training for lawyers or judges that aren't taking place?
Well,
I'll jump in here if I may, and then we can come back to the training question. Is I think whereas the top level headlines that people often see are these very partisan and fractious debates,
the hot button type
the
issues.
sort of hot button work that you see in the headlines we read about Congress and the difficulties of passing legislation quickly. There's a lot that is in the second level headlines below the fold, if you will, that's taking place now when we talk about bringing openness to government, bringing change to government. Again, on 2 weeks ago, on April 7th, every single one of the major cabinet departments and agencies released a new open government plan that set out a forward-looking strategy for how they're going to bring change to the way that they work. And every one of those plans has a flagship initiative, and some of them have several, which are, again, very ambitious plans for fundamentally changing and reorganizing the way work is done in the agency to ensure that it's more open, that it's more collaborative, that it's more transparent. Today, we just released, just this morning, an assessment of these open government plans, including a self-assessment by the agency. So every single agency took a hard look at its own plans to be more innovative and open and said, here's how we think we can do better even than what our own plans set out. And we're moving now towards a process of implementing these plans so that we can bring about change quickly. A lot is going on in the executive branch in this regard. And then let me give you a chance to sort of weigh in, and then I want to come back to this question of education, because I do have some thoughts on this one, too.
I think, to be sure, anything that's within the existing enabling statutes and you can do by regulation or executive order, I mean, that's much easier to get done. I think in terms of adjusting the overall privacy laws, it takes a little bit more effort on the private sector basis. Yeah. And certainly in the legal profession, while we're examining the impact of globalization and technology on our system of governance and our system of ethics, we'll take a year to study it. Then we have a year of the proposals, to deal with it. We'll have a year of implementation, passing it in the ABA, getting it out to all the states where it needs to be adopted. The states will then adopt. So it's a 3 to 4 year process to make the kinds of changes that are going to be needed. In the interim, what we might do is publish some, memos or suggestions in terms of here are the best practices for lawyers to follow, and we suggest you do this, but you can't make changes to the rules overnight.
And that's not necessarily a bad idea, because you don't want changes that are based on specific technologies that we know today. We all know that, we wrote laws based on technologies like the DAT. Remember the DAT?
Sure.
That was a technology that existed for about 3 seconds. And we've moved on since then. So we wanted to have enough time to understand the principles of the change without tying them necessarily to one specific device that may, today the iPad is the latest thing, but a year from now we may not remember the iPad anymore.
Central to effective government or effective legal system is trust, buy-in from the people governed or adjudicated. What do these changes and emerging technologies and all the things that we've been talking about offer us as either opportunities or challenges in regards to trust, building trust or repairing trust? Many of these institutions are not very trusted these days.
Trust is really I think it's the central word in terms of the work that we do in trying to bring about a more open government. It's trying to repair the trust or create the trust between the American people and their government. And we're seeing, look at the approval rates of politicians in this country, the approval rates of government, the approval rates of Congress, are at an all-time low. And yet, we just came out of an election cycle that witnessed the most robust participation we've ever seen in an election cycle. So we want to try to bring back, there was an enthusiasm that was created in that election movement in 2008. We now need to try to harness that to the work of governance, not simply to the work of politics and the work of elections, by repairing that trust, by creating opportunities for people to engage with their government and create opportunities for participation, by being more transparent and releasing more government data than we've ever done before, as we're now doing through vehicles like data.gov, where you can search for and find more government information that's ever been available. Because if we're not showing what's under the hood, if we're not actually opening up the doors and the data of government and then giving people a chance to weigh in based on the information that they're getting, there's no reason why people should trust what goes on in Washington. So we need to really, my work really centers around, and the work of my colleagues across all of the agencies, on trying to repair exactly that, build that kind of trust that you're talking about.
Carolyn, it's not just elected officials, lawyers and journalists don't do too well in the trust.
That's right. No, they don't, do they?
Either.
And certainly that is of primary concern. The technological advances permit lawyers to deliver their service much more efficiently, much more effectively. I mean, you can search 1 million documents in minutes if they're digitized, and you can do a word search and you'll pull up everything. It really provides an incredible tool for the practice of law, for the resolution of disputes, which should enhance people's trust. I think where you have to be concerned is that the lawyers must be able to assure the public that, in fact, the level of competence, the level of the product is equally reliable. And that's some of the work that we're doing to ensure that what you think you're getting is what you're getting from some of these distant providers or whatever. We have to be able to be sure that the public knows they are protected, that they can rely on what lawyers are providing for them.
Time for a final quick thought.
Oh, just a final quick thought on that. One of the things that happened this year that was of great note and excitement to me is that the National Archives released the Federal Register for free. So now in downloadable format, in a raw downloadable format. In other words, you can take the Federal Register and mash it up so that this once PDF, hard-to-read newspaper of our democracy is something now that others have turned around and turned it into a tool that you can annotate, that you can search by geography to find all the actions in government that are taking place related to my community. That's really exciting. But what's important to that is that, to follow on this point, is that these are authenticated copies of the Federal Register. So it's a downloadable version that's free and accessible to all, but it's authenticated, that you can trust the document. I think it's the same thing again with regard to lawyers and legal services. Is we have so much information out there that's available for free and should be, but turning that information into knowledge and using it to solve problems is something we're still going to rely on lawyers to do. Authenticating documents is still something we need government to do, and we need that role to be played by the intermediaries that can help build that kind of trust.
Thanks to both of you. A fascinating area. Wish we had more time to explore. Both of you are certainly in the catbird seat, and not only watching these changes, but leading some of these responses to changes. In addition to thanking our guests, I want to express gratitude to our friends at the American Bar Association's Division for Public Education. Thank you for collaborating with us on this Law Day 2010 edition of Dialogue. Special thanks to Mabel McKinning-Browning and Howard Kaplan. And to those of you watching on MHZ or listening on radio, we appreciate your comments and encourage you to share them with us. You can do so by sending email to dialogue@wilsoncenter.org. We'll return next week with another edition of Dialogue. Until then, for all of us at the Wilson Center, I'm John Molesky. Thanks for watching.
Dialogue is a co-production of the Woodrow Wilson International Center for Scholars and MHZ Networks. Dialogue is available via broadcast, cable, satellite, and telco on MHZ Worldview throughout the United States. To see how to watch where you live, visit www.mhznetworks.org.